Good afternoon. My name is Brittain. I'm a partner at Thompson Hine in the White Collar Defense and Investigations Group. Thank you for joining us today. This is the 12th in our series of webinars concerning the shift in presidential power and what that might mean for our country. I'm joined here today with my colleague, Mark Cipolletti, also in the White Collar Group. Before we begin, I wanted to go over a few housekeeping items. Today's program is being recorded and we'll send you a link in a few days. Also, this presentation is intended for the general information of individuals and organizations on matters of current interest. The thoughts and opinions expressed today are those of the individual panel members and do not necessarily reflect the opinions of the panel members' clients, employers, affiliates, or Thompson Hine. The content should not be taken as advice, as the views expressed here are for informational purposes only. If you have questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen. We will answer as many of the questions as we can at the end of the webinar. Also, CLE credit for today's webinar is pending. Please be sure to complete the verification of attendance survey. The link to this survey will be posted in the chat. We will also paste the link in the chat at the end of the program, and I will announce the tracking code at the end of the program. In the handout panel, you can also download a copy of the PowerPoint slides and our bios. All right, and let's see, get started. So good afternoon, everyone. Again, Brittain Shaw here with my colleague, Mark Cipolletti. And we're going to be talking to you about why corporate citizenship is not a shield under this new administration and why every business needs a white-collar defense strategy. We're going to be focusing on 4 different areas. First off, we will discuss the white-collar enforcement priorities of this new administration. Then we're going to talk a little bit about what to expect from DOJ and other government regulators, including state AGs and foreign regulators. And then we'll move on to what these new priorities mean for you and your company. Finally, we're going to drill into sort of more nitty-gritty about what you can do to prepare for and manage risk during this time of change and uncertainty. All right, so what are the new administration's enforcement priorities? Well, the day one announcement from DOJ was the total elimination of cartels and a focus on national security. And of course, with cartels, that involves drug trafficking, human trafficking, and all sorts of illicit conduct that goes with that. In conjunction with that, the second initiative would be illegal immigration and how we can stop the flow of undocumented migrants into the country. Mark,
go ahead, Brittain, sorry.
No, I was going to turn to you.
All right. I was going to say, one of the things that we've been seeing a lot of, both in the news and questions from clients, is surrounding immigration raids, and what businesses can do to prepare for that and protect themselves when it happens. They are occurring with increasing frequency, and they are hitting all sectors from manufacturing to construction, regular brick and mortar shops, you name it, even institutions of education, higher education, and certain religious gathering places, churches, synagogues, mosques. So no one is really safe. Nothing is off limits. That is a priority that is being enforced aggressively. And one of the things we'll talk about later is how you can sort of shore up your defenses against that, as well as things that might be related to it: searches, search warrants, seizures of information and evidence as well. Another priority of the administration has been protecting American businesses in the global economy. And that's a multifaceted approach we're taking, from seeing a shift in white collar enforcement and what the goals and strategies behind it are, to prosecutions or investigations of multinational companies that are not US based, that are viewed as being competitive to American companies or somehow hurting American companies in the global marketplace. And that's where we've seen one of the biggest shifts in FCPA enforcement. Again, to be mentioned later, but that doesn't mean this is going away in any stretch. It's just a reprioritization and a different way of looking at the laws and the policies that are there.
One other feature that we're seeing is the streamlining of enforcement power. I know there's a lot in the news today about government efficiency, and DOJ is, not being ignored in that regard either. We've seen some transformations of power from Main Justice out to the U.S. Attorney's offices, giving them a few more tools in their toolbox. We still expect to see that there'll be centralized policy directives coming from Main Justice, but what it means when they're rolling out additional powers to the U.S. Attorney's offices, at least what we think as former federal prosecutors, we're going to see faster moving prosecutions because there's just less bureaucracy at the U.S. Attorney level. We're going to see, more aggressive prosecutions, and obviously that increases the number of different locations and venues you might see prosecutions coming out of. So as the new teams get in place, as new U.S. attorneys are appointed, confirmed, and they fill out their teams, I think we're going to start seeing more aggressive and faster moving prosecutions because of this effort to get the resources in place at the sort of local level or state levels, state federal level, and move things more swiftly.
And you'll also see that too in prosecutions coming out of Main Justice. They're reconfiguring some of the personnel there, including from the section from which Brittain and I came, the fraud section, to basically make that a more streamlined and efficient process. And what likely might happen there is that you'll see cases wholly coming out of Main Justice rather than partnerships, which does tend to slow things down. And the chain of command will run directly to the front office, for lack of a better word, to avoid having 15 steps in a process. So what that means is things are going to unfold quickly, and you need to be ready for that if and when it does.
And one more recent addition that we think should be included in sort of the white collar enforcement sort of outlook is this notion of data security being a matter of national security. There was an executive order that came out at the end of 2024 under the prior administration, and it concerned, data privacy, in terms of, let's say you're a big data collector and you have geolocation data, that sort of sensitive information about American citizens. Well, on April 11th, the National Security Division came out with some guidance, so a fairly lengthy guidance on this executive order and the various ways of complying with the protection of Americans' data, particularly directed at those companies or businesses that may not only collect it, but then also sell it. So that is something that we would expect to see possibly some enforcement action down the line. The guidance includes mentions that failure to follow these guidelines may include civil and criminal prosecutions. So that's something definitely to have on your radar screen. So in light of these enforcement agenda items, what are we going to see from the actual enforcement bodies? That is DOJ, SEC, CFTC, state regulators, and so forth. I think it's as part and parcel of protecting America in the global economy. And I know we have all heard the word tariff recently. We're expecting to see increased trade crime prosecutions. And that means, customs evasion, tariff evasion, export and sanctions evasion. I would also expect to see increased prosecutions down the line of economic espionage. I mean, particularly historically, China has been a major player in that realm. So to the extent that an American business is the victim of intellectual property theft or otherwise, we would expect to see those kinds of cases prosecuted aggressively. And flowing from these trade crimes, I think we're going to see some increased prosecutions in the money laundering space. In other words, transactions that, let's say a business that is working in Mexico with a subsidiary, and there are transactions that touch on some cartel interest there. I think we're going to see a large spillover effect into money laundering prosecutions for things that we might not have previously seen front and center in terms of money laundering focuses. So again, it's going to be a shift towards looking for ways that money is flowing to or from cartels, foreign terrorist organizations, and how potentially a business might be either willfully blind towards interactions or maybe deliberately doing business with them in a way to give them some unfair advantage over other competitors.
That's right. And in addition to the typical trade crimes that you would think of, there's going to be a lot of increased scrutiny, and we've already seen it in terms of trying to avoid or somehow minimize tariff obligations. The tariffs are an important part of the structure under the new administration, and the administration believes that in the long run, these will be more effective in developing a robust American economy. So it will not look kindly upon people who were companies who are doing anything to subvert those efforts, including, maybe not being completely honest with point of origin, country of origin, where things are being held, what is being done to them, or, again, moving them through certain countries with lower tariffs in order to avoid incurring those greater costs. Another thing that we've seen a lot of in the last few months is an increased scrutiny on government contractors, grantees, and others receiving federal government funds. So sure, in the news lately, a lot of institutions of higher education, including Harvard, have been the subject of particular executive orders or withdrawals of funding, withdrawals of grant money, and cutting that off. But there is a lot of increased scrutiny surrounding government contractors because it goes to this greater principle of protecting the public fisc. So one thing that we've seen in the firm is contractors having to fight a little bit harder, and actually maybe a lot harder in some situations, in order to get paid for certain services that they think they believe they rendered under a contract. So, for example, where the dispute process may have been a little bit more streamlined or forgiving to the contractor in the past, that's certainly not happening now. The default is the less the government can pay you, the better. So it is best to make sure that you are consulting with your legal team in advance to make sure that you're not going to do anything that you're going to have to fight about longer and harder later. There's also, to the extent that there are businesses that are tied into other government programs like Medicare, Medicaid, TRICARE for members of the military, anyone who is billing government for services, for goods, for products, there is going to be a greatly increased scrutiny on them. The healthcare fraud section in the Department of Justice, which has offices throughout the country, has been seeing more and more work every day as the government has been ramping up those prosecutions and literally directing resources and bodies to those cases. So you're going to see more healthcare fraud prosecutions. You're going to see violations of the False Claims Act, which we will be talking about throughout this presentation, as well as the anti-kickback statutes too, for healthcare companies that are in that space.
And I would just make one addition. It hasn't happened yet, but there is a proposal in Congress for the creation of a task force of sorts at DOJ to prosecute more broadly trade crimes, but particularly things that are directed at Chinese companies that may be, again, interfering with the competitive advantage. So we're watching that, and I wouldn't be surprised if we were to see some of the resources, both at the fraud section or other divisions at Main Justice, redirected into something of that sort, since it does have bipartisan support, at least within the House, and then obviously it's very much in sync with the president's agenda.
Following along that, when we're talking about False Claims Act prosecutions, there's two prongs to this that you really need to be aware of. One is a criminal prong, which the government itself would prosecute. There is also a civil prong to the False Claims Act, which the government can bring on its own. But there is also now a lot of vulnerability, as there always has been, to claims brought either by relators in key TAM cases, also known as whistleblowers. Over the past several years, we've seen a huge increase in whistleblower programs, not just at the DOJ, but the SEC's has grown, the CFTC, almost every regulatory agency, Treasury, IRS, and even certain specific districts like the Southern District of New York, for example. But right now, the Treasury and FinCEN are standing up a whistleblower program that is going to be very robust and encompass a lot of what we are seeing the new administration focus on in terms of trade, who you do business with, who those people do business with, in order to capture a lot of this enforcement that is certainly going to be down the road. But be aware, in a competitive environment, a competitive marketplace, and this happened under the first Trump administration, increase in individuals bringing False Claims Act, whether that be competitors, your competitors, or a disgruntled former employee, any other type of whistleblower. There's going to be a lot more of those. That was true in the past. It certainly would stand to be true going forward, and particularly where the government feels as though you're not following the rules, you did not answer questions honestly on any form that they got. That's a really easy FCA prosecution for them to undertake, whether it be related to DEI or anything else that the administration views as illegal discrimination, quotas, or anything else adverse to the public America First interest.
I would just add too, we've touched on it before, but there is going to be increased scrutiny on businesses that are in the cross-border space, and in particular those that have touch points in some of the problem areas for cartels and terrorists. And this, to some degree, may conflict with what was announced at the beginning of the administration, where there was, going to be a pause in FCPA prosecution. So that you may see that there's some tension there. But I guess there was a few thoughts about that. One, remember, it's a pause in FCPA. It's not a termination, and we expect probably at the end of the pause period that there's going to be some articulated guidance about how they're going to approach FCPA cases beyond what they've already intimated, which again is going to be focused on those businesses that may have touch points in Mexico or cartel influenced areas. So again, even though there seems to be a pause, and maybe people think that, overseas businesses have somewhat of a pass, I don't see that to be the case. We've got, again, there's statutes of limitations that are at play, so it's, may outlast this administration. So you certainly don't want to think that this is all systems go for foreign corrupt behavior. And Mark, did you have something to add there?
No, I was going to say, just as a simple thing, the statute of limitations under the FCPA is 5 years. That is longer than any term of any presidential administration. Not to mention everything that companies are going to have to deal with increased foreign scrutiny of U.S. businesses and U.S. companies, right? You can even sort of look to current events. What is Canada doing? Look at who has been elected as the Prime Minister of Canada, under the agenda of, if America is going to punch us, we're going to punch back harder. Expect to see a lot more of that through the global landscape. So in addition to all of those things, there's also cases that we've seen precedent for in the past, way before Trump. Companies that were tied to FTOs or DTOs, and I don't mean directly tied. We do business in Colombia. We hire a security company. Chiquita Banana was the the organization. They're hiring a security company at high-risk areas of Colombia. They hire the best one out there. It turns out some of that money goes to foreign terrorists, a designated FTO, a foreign terrorist organization. They were prosecuted under the FCPA. A similar case with a company, Lafarge, it's a French concrete company. They were prosecuted under the FCPA because money was going to a designated FTO. And there's going to be a much harder look at that. And we've already seen the number of designated FTOs go up exponentially in the last 3 months. So to think that this administration is going to be shy about that or back away from it would certainly be underestimating the preparedness level that you need to have for if you're doing cross-border work.
So what are some of the other regulators up to? I mean, we've covered DOJ sort of broadly, but I think that the sense is with the SEC, where we just had the new leadership. I think it was just this week, if I'm right, Mark. Paul Atkins in place, and what are we going to see both with respect to the SEC and CFTC? I know that a lot of people have been watching what they were the prior administration was doing in the crypto space, and in this administration, there's been a very clear signal that it's going to be, there's going to be guidance. It's not going to be a heavy-handed regulation by to the extent that SEC is prosecution, albeit it's civil. But we're expecting to see some useful guidance in that space rather than again charge first and figure it out later.
I think that's exactly right. It's confusing because some of the initial takeaways, people were talking about less regulation in the space. In a way, that's sort of wrong. What the objectives of agencies like the SEC and CFTC are, and going forward, are going to be actually come up with regulations, come up with rules that can be followed, and then if there is a violation of these rules, we will think about ways to prosecute them, whether it be bringing civil actions by that regulator or by the DOJ prosecuting it. So I think you're going to very quickly see an uptick in what I would call bread and butter cases. So insider trading, market manipulation, your classic securities fraud type cases. Those prosecutions are going to go up. And rather than trying to create rules that people need to follow in the crypto space or anywhere else by doing these test cases of, well, let's just prosecute them for a wire fraud or a bank fraud and see how it goes. Those are going to go down because they're going to actually ask the regulatory agencies to do their job and regulate and come up with clean rules and clear rules, which when they are violated can be prosecuted aggressively. So I think we're gonna see a lot more of that. Ponzi schemes, insider trading, anything that could hurt consumers or the investing market at large. If there is a false statement that has a major market impact, that is something I would worry about. I'd want to make sure that any public statements, if I'm a publicly traded company, are wholly accurate, because if that has a massive impact on the market, that is going to be something that the administration and the enforcers are all over quickly.
Right, and I would just add a footnote there, sort of jumping back to DOJ. As Mark and I recalled at the fraud section, oftentimes when you have an SEC investigation into any of these so-called bread and butter cases, the larger ones would often have a parallel DOJ grand jury investigation, which you may or may not know about at the time. So just a footnote that in addition to the uptick in trade crime prosecutions, I would expect that there would be a return, at least in some fashion, to focusing on DOJ prosecuting things like investment fraud, Ponzi schemes, and so forth. They've never they've never stopped doing it, but over the years, there might be a shift to particular agendas. So I would expect it to go back to at least prosecuting truly egregious ones, that we've seen. I mean, there were certainly the fraud section in the past had handled some of the major Ponzi schemes that were out there. So hopefully that will be something that we see.
And that's where there's a huge benefit to having a team of lawyers that has been on the criminal prosecution side, because you might not know that there is a grand jury investigation going on. You may think you are just dealing with a regulator or with a different agency, perhaps a state AG or something like that. But having seen the way those investigations work, how information is requested, the form in which it's coming, who is asking for it, and how they're asking for it, can often be very indicative. And the way that you would want to handle a regulatory investigation sometimes is the same that you would handle a criminal investigation, but there are often some very distinct differences and some things that can be very important to the long-term success in any type of litigation like that.
I think also in conjunction with, having the SEC return more towards, providing guidance and regulation as opposed to, sort of, again, regulation by charging. We're going to see that in other areas. There were various initiatives that either came out of ATF involving, vaping, and PACT Act, which is, involves cigarettes to or e-vaping to minors, initiatives that were sort of DOJ and a traditionally regulatory agency, whether it's FDA, ATF. We're going to see a retreat from that. We already have. I mean, things are in pause mode, and I wouldn't expect them to start up. And probably similarly, any sort of joint EPA, DOJ type initiatives, I wouldn't expect those to be at least a heavy focus. That said, where the federal regulators step out, we're going to see, and various state attorney generals have already come out and at least given lip service to the fact that they're going to move into the spaces vacated by DOJ. In particular, California State AG talked about the FCPA and how, foreign corruption by California businesses won't be tolerated. Similarly, Alvin Bragg was recently speaking and talked about how his office was going to be looking into increased white collar enforcement. So that's kind of a big TBD, but certainly one area where we've seen it continue, some at least efforts continue, is in data breaches. I know that DFS in New York and the state AG have been seeking fines for data breaches in recent days, and so we would expect that to continue, even if there's been somewhat of a retreat on the SEC side, where at least there was policing of inadequate disclosures about cyber breaches and so forth. I think we're going to see state attorney generals occupy that space because, frankly, it's, getting fines, keeps them running, and it's sort of low-hanging fruit. At least they seem to think so.
Yeah, and to couple with that, this isn't a new thing. We've seen it throughout administrations over the last several decades, where when there was a Democratic administration in place, traditionally Republican states would start prosecuting or focusing on things that they believed were more important to their agenda, and vice versa. So this is nothing new, and it's going to be an easy lane for state especially aggressive state attorneys general to fill.
And finally, I think we're going to see, I know we're going to see continued enforcement by global regulators. I think this week there was discussions of the Dutch prosecution service pursuing some fairly large foreign corruption cases. One question mark that I have, and I think that will be discussed in the coming months, is sort of with the U.S. at least on pause or possibly stepping back from the foreign bribery front. A lot of times what we saw at the fraud section, when we had many cases that had cross-border connections, in other words, just like we had parallel investigations with the SEC, we would have parallel investigations with the FCA in the UK or the Serious Fraud Office, Dutch prosecutors, Swiss, even in Singapore and so forth. What's the level of cooperation going to be if DOJ is sort of stepping back? Because I think there was a lot of, the ability to obtain information from foreign regulators and likewise those regulators from us may be slowed a little. So while I expect them to step in, I'm wondering how the U.S. stepping back might affect that. I don't know if you have any thoughts about that, Mark.
So yeah, and I do think that there has always been a level of cooperation that's been anticipated or expected. One of the things that we do know is that even when there was full cooperation, sometimes it was a little bit like pulling teeth, for lack of a better word, just because you still, in addition to having someone say that they want to help you and they want to agree to it, there's different rules in every country. And a lot of times the restrictions on getting information from countries in the EU are very different, even if they want to be helpful on what we can and cannot do in the US. So I will say a lot of that information is transmitting between the agencies, the investigators. I don't know that that will entirely slow. I mean, you might see the United States being more, or I should say more reluctant to sort of pass off information about a purely US company. But, you know, there's certainly mechanisms, including the courts, by which foreign authorities can get it. So I don't think it's not a safe space by any stretch. And there will be mechanisms, and there are mechanisms in place by which to obtain that information that isn't going to be highly dependent on the particular administration that's in charge at the time. You know, there's other hurdles to get through, and in many ways they can get the information as easily as we can in some situations, especially with the global marketplace. If you're talking about data that is stored in other places, like first thing the prosecutors always ask for, emails, phone records, they're going to be able to get that sometimes a lot faster than we will, and we would rely on them to get it.
So what sort of tools are prosecutors going to use to execute on these new enforcement agendas? We've talked a little bit about bread and butter cases, and so, you know, that would be in the securities fraud Ponzi scheme world. I think that the wire fraud statute, and I think it was, I'm going to probably misquote it, Judge Rakoff or somebody described it as, you know, the prosecutor's Stradivarius or something, you know, favorite tool. But I think we'll continue to see that used, and I think appropriately in a lot of the bread and butter cases. And it's certainly a very streamlined statute, very, you know, easy for juries to understand. And so we'll continue to see that being used moving forward. When we're getting into the issue of trade crimes and tariff evasion and so forth, there's more tools. I mean, there's always more tools for the prosecutors, but certainly, you know, you always have the issue of false statements on government forms. There's the smuggling statute, wire fraud again, of course, and then False Claims Act cases. Again, I think that even though we may have, there may be more statutes out there, prosecutors typically like to keep it simple, or at least the good ones do, because it's easy for the jury to understand. It's easy to organize your evidence and proof. So I don't think we're going to see any particularly new use of sort of antiquated statutes, but perhaps you have a different thought on that, Mark.
No, I mean, that's the whole point in listing them here, right? Like, in terms of this, nothing's changed. It's going to be the same tools, maybe a different emphasis on some. Again, I don't think we can stress it enough. False Claims Act prosecutions, because they're simple, they're easy, they're straightforward. That is going to be routinely in the prosecutor's toolbox, especially with the goals and agenda of the administration, right? It's easy to prosecute someone for saying, we made something material, whether it be through executive order, statute, whatever. We told you it was material. We told you not to lie about it. We told you not to do it, and now you did it. And we found it. And that's a very easy, straightforward case. As you said, I think, you know, many moons ago when I first came over to the fraud section from the corruption unit, the first thing I was told was everything's wire fraud, and that's almost certainly true. There have been very few cases where you could not find a wire fraud charge to include. And that in and of itself separate conversation for a separate day, but it allows prosecutors some leeway in terms of sentencing, in terms of maximum exposure. It's just an easy thing to include, and we're going to see that. Same with false statements, IEPA, conspiracy. Conspiracy is a favorite charge of prosecutors because it allows them to bring in a lot more evidence, and about a lot, multiple individuals, entities, whatever, than they would, again, in a strict prosecution of Brittain Shaw for, a false claim. Much easier to charge the two of us and then get in all of the evidence. So I think that the tools that they use are going to be the same, and then we're going to see the shift in cases. And I don't know if you want to get into that, of just back to the bread and butter.
Did I advance too soon?
I thought so. But
okay.
Yeah.
So sure, yeah. I mean, we're gonna see. I think, particularly in the trade crime space, I would expect to see the 371 client conspiracies. Conspiracy against, sort of customs or whatever government agency. That would be very easy to establish when you're, trying to either, fit whatever the particular trade crime is, whether it's, tariff evasion or transshipping, misrepresenting country of origin or value of goods. All of those could easily be slotted into one of those, like I said, conspiracy. And again, it has the advantages that you just talked about, Mark.
Right. And, again, if there's any touch to that whatsoever, we already know that those are out of the gate huge administrative priorities. So, certainly expect to see that. But I think the important thing is to remember that it's not just what you're doing. It's really like that. You need to know who your contractors are, who your employees are, who you're engaging in with business overseas, particularly. That is going to be a massively high risk to any company that is doing work overseas, particularly in certain countries like China, Russia, anybody that's going to be high on either a tariff list or, where we would consider, where the administration would consider it to be a high risk of FTOs, DTOs, and things of that nature, because it's those relationships that could really get you in trouble. And if you're not compliant and have like the effective controls in place to make sure that you're not doing business with any of those entities or not paying money that eventually goes to any of those entities, there's a huge risk and huge exposure that may not have been there before. And in the last 4 years, it may have been okay to say, well, we had a compliance policy in place and we really did think we were doing a good job and we thought it covered it. I don't know that that's going to be the same for the next 3.5, 4 years or however long. I think that calculus might change. It's going to be like, you should have known.
Right, and I just skipped one slide because I think you covered it very efficiently. But I mean, we are in a changing landscape, and I do think that it's wrong to think that we're going to have a vacuum in the white collar enforcement space. It's just going to be a different focus. And as you pointed out, for companies that are doing business globally, which is, seems like everybody these days has some touch globally in terms of your supply chain or whatever, it's going to take a lot of due diligence on the ground and retooling of your compliance programs, training of your employees so that they know how to spot these risks. And our view is that now is the time to do it, not wait another year and see like whether DOJ or the administration is really serious about going after this, but like get in front of it, because to the extent that you have a business that is located in Mexico or is part of your business there, and you have a supplier or an employee that you determine through use of either outside counsel or potentially even, I know some people have been using security firms as well to go to some of these high risk areas to sort of really kick the tires, so to speak. But the sooner you discover that and remediate, and then you go through the calculus of whether to self-report or not, the better. Anyway, that sooner is better in terms of determining whether you have a problem, because you don't want to be the poster child for this new agenda. I mean, that I think is clear.
Exactly right. And, you know, the thing that white collar lawyers can do a little bit differently, it's, you know, it might be unpleasant. You probably don't really want to have to talk to us because it's a little bit like going to the doctor and, you know, like going to point out things like, hey, maybe you could do this better. Maybe you could do that differently. But the job of a good white collar lawyer is to press where it hurts until you find out what the problem is, right? And that's going to be where the risk lies under the new landscape. And that's why it's important to have that involvement up front, because you can avoid it. And kind of going, I'm assuming we're going to roll to the second point here, which is, no, sorry. You're doing like the laboring order. You got the talking, you got the slides.
Move the slides, sorry.
But expecting the unexpected, I think, you know, every time there's a change in administration, the default is like, well, things will change a little bit, but how much could they really change? Well, we're learning how much they can really change. The president came in with an aggressive agenda, but a very intentional agenda. And remember, you know, he was the president 4 years ago. And as he has said himself, I've learned things from that. And I know what my vision is, and this is how I want to implement my vision and, you know, the collective vision of the administration. So these changes are happening dramatically, and things that people thought would always really be the same and wouldn't really change are changing. And enforcement has become highly focused on achieving those goals, and it's been swift. Brittain, you mentioned this before, like, you know, the whole concept of DOGE and government efficiencies and things lingering on. You know, even the concept of like, wow, it really seems like they're taking a sledgehammer where one would take a scalpel. And the administration's response is, yeah, because when you take a scalpel, things happen really slowly. There is no change and everything just goes by with the status quo. Here, they're like, no, these are the policies. We're going to enforce them. And it's going to happen very fast, and then enforcement is going to be right on the tails of it. So there isn't really that time to prepare. You just have to sort of figure out the landscape, and as we said, sort of go in and do a deeper dive so that you are ready for those changes and any type of enforcement that would come.
And I think too, you know, over the years, you know, certainly DOJ has had they're still in existence, the, you know, various corporate compliance guidelines, a lot of policy documents that are out there to assist companies in making, you know, evaluating their compliance programs, or, you know, how, you know, self-reporting might, you know, benefit you and down the line. It's a real question of how those are going to be not honored, but, you know, I think at the beginning, you know, sort of day one of the proclamations was, you know, none of these illegal policy memos are not necessarily specific to DOJ, but are going to be followed. So I wonder to what extent any of those will be, you know, withdrawn or significantly retooled. So it's kind of, there's an uncertainty, right? Because there's a lot of, you know, a lot of work went into those, a lot of thought about, you know, advising companies so that they could, you know, invest appropriately in the kind of compliance that DOJ would want, you know, to foreclose, you know, some of the bad conduct. But it's a question mark whether, if a company relies on those now, you know, how much play will that get for them under the new administration? And again, to me, I mean, hopefully they would get credit, but all bets are off.
Well, certainly, and you know what the credit looks like. I think there's a lot of principles that you can take, especially if we're thinking about compliance. And you know, one thing that we know from regularly interacting with the department and other offices is the compliance teams are still up and running and sort of making sure that they're holding true to some of the really basic principles of that. Now, you know, you might see a lot of pushback on, for example, the DEI component that was in compliance monitorships. I would not expect that to be, in fact, we know it's not going to be included in monitorships under this administration, under this department. but the core principles of like, hey, were you actually doing something proactive versus sitting on your heels and waiting for us to come after you? I think those things are always going to be true, and that's where the risk calculation kind of comes into effect of like, well, okay, where's our exposure? What do we know that this administration cares about? So it might not be exactly the same as it was a year ago, but the principles of like what to do when you find the risk, I think those hold as a good guide for what to do going forward, until we hear something different or see something different.
Agreed. So given,
sorry, just a couple on that. We're spending a lot of time on DOJ. Don't forget, like, there's still the regulators, there's still the state AGs and foreign enforcers that we were talking about too, and there's a lot of guidance in department policy that applies equally to them and other government programs.
So given this environment that we find ourselves in of, rapid change, rapid shift in enforcement initiatives, and obviously, some degree of uncertainty about how it's going to play out, what is a company to do to, during sort of this initial period, and then, sort of looking forward down through the next 4 years, how can you best protect yourself from staying out of the crosshairs of DOJ or other government regulators?
Because one thing we know is certain, again, like the principle of an administration lasts for whatever it's going to be, 4 years. In this case, it can't be more than 4. But even if the Republicans were to win the House and even the Senate and White House, or I'm sorry, the White House and the Senate and the House of Representatives, that doesn't, things are going to change. And all of these policies, everything you're going to be doing, it is never going to be good enough for the folks in place now and whoever will be around in 4 years, 8 years, 12 years to say, oh, I didn't really think that mattered. I didn't think that I was doing anything wrong. I didn't think you, DOJ, SEC, CFTC would care. That's never going to be good enough. So it's just kind of like you have to fight the war on all fronts.
Sure. So, the way we, white collar attorneys think about things is always, a good defense is the best offense. And what are you to do? We can't underscore this enough. I mean, right now, as I said previously, is the time to engage outside counsel and, again, security firms if necessary, particularly if you, have business being conducted in sort of what I would consider a high risk area, to really audit your own unique risk profile. What risks your particular company may be exposed to, and obviously that's going to be very different whether you're in, manufacturing versus, simply transport, or, data collection of some kind or data service. It's all going to be unique to your business. So there's no one size fits all, and it's going to be a very bespoke process. And again, it's going to take some time and some expense, but I think it's worth doing because, again, the expense of being on the wrong side of it, I think, could be fairly catastrophic. Part of this, again, goes back to compliance, and Mark touched on this before. We talk a lot about, we have a complaint line or whatever, but I can't tell you the number of times I've heard where, or experienced back when I was a prosecutor, where the complaint line sort of, it was an email, box that got filled up and somebody checked it maybe once every 3 months. Well, that's not good enough, right? So, again, every kind of compliance and sort of complaint line that you have really needs to be meaningfully thought out, really needs to work. And again, in this whistleblower sort of environment that we're in, it's important that you have that so that you can meaningfully document the complaints, investigate them, and make sure that they're escalated when appropriate. And so that's something that outside counsel can certainly help you develop if you don't have one that's really up to date, and particularly with respect to businesses that may be doing business in these hot button areas. It's very important to take into consideration all the unique facts that are on the ground, and make sure that you have employees there, not only that don't present problems, right? So there's going to be an increased vetting of employees on the ground in these areas, but also ones that know how to spot the red flags, right? Your compliance system or your complaint line is only so good if nobody, unless if you don't know what a problem might look like, you're never going to either have it reported. If employees don't know that they should report it, or even that they're required to report it. So again, it's really going to be a soup to nuts look for those companies that do business, across borders, at who you're doing business with, who you're working with, who you're employing. All of that needs to be looked at.
And those internal complaint processes are going to have to be accessible, easy to understand, and most importantly, protect anyone who is making a report to the line. So they're going to have to be handled with a level of confidentiality, and be able to triage them and not just, again, sweep something away because it doesn't seem like that big of a problem or that big of a deal. There has to be a logical and reliable method for evaluating these. And those are the types of things that when you're evaluating compliance, you really need to look at in terms of how good enough is it. Not just that there was a line, not just that there was somebody that responded to it or said, okay, thank you, we understand, and your name will be removed from documents. That's just not good enough. Governments, the US government and other governments routinely pressure test these things to make sure that they are fulsome and actually effective.
Right, and just jumping back to sort of the broad concept of trade crimes prosecution, and I'm envisioning sort of, making, programs to ensure that your customs forms are being, filled out appropriately and are accurate and so forth. And, again, it's worth it to take a look now to make sure that, T's are crossed and I's are dotted, and get those things in order in that regard, because government has many resources, and one of them certainly with respect to customs is there's a lot of data that is compiled by customs on all of the shipments in and out, and they use algorithms to determine patterns of potentially of shift of where goods are moving, to highlight perhaps there's been some improper transshipping or underpayment of certain tariffs. So again, no matter what your company's area of work might be, if it's in the customs and trade cross-border area, it's going to be really important to make sure that you've gone over compliance and training and best practices, on the ground for these forms, and because government is already sort of ahead of you in terms of their ability to have all of the data that gets input into ACE.
And even too, if you have executives or other high-ranking folks in the company traveling overseas with their cell phone, a work cell phone, a laptop, what is their susceptibility to, a warrantless search at the border when they're re-entering the United States? Like those are things that need to be evaluated and accounted for, like those sort of intangible risks. And another thing, I think it was just on the previous slide, even simple things, right? And we've seen a lot of, for lack of a better generalized word, workplace visits from law enforcement. And just having a protocol in place and knowing what you are supposed to do and making it simple for someone who is just working at the front desk to understand, so that they know, well, wait, what should we do in this situation? What can we say no to? What do we have to allow? Is it an administrative warrant? Is it a search warrant? Is it both? Is it a visit because of like a PACT Act visit, which is going to be handled differently than the other two? And what are the requirements? What do we need to do? What can we say no to? And how can we best defend against something like that happening before it occurs? And then those are all just a short slice of things that you can have in place ahead of time to make life easier and risks lower.
Right, and I think certainly, you touched on the issue of being ready for sort of search warrants and having a plan. We're seeing a lot in the news today, obviously, about ICE raids and immigration raids, and I expect, at a certain point, that's going to flatten out, right? There's only so many people that you can, either detain and remove, and then they're going to have to shift. And I wouldn't be surprised if you're going to start seeing more warehouse-related raids, potentially. My brain gets spinning about thinking, well, let's say somebody gets picked up in an ICE raid, and then they're like, well, I can give you information about, customs evasion at this warehouse. I mean, this is sort of how these things could come about. And so, there's the real situation that you may be faced with a search warrant at one of your warehouses or even places of business. And it's, I don't think that, it's not as if you're going to have your general counsel on site when this happens. It almost never, unless they're there at like 5:30 a.m. or 6 a.m. every day. But, invariably it's going to be a couple of phone calls before even an attorney is contacted. And so one of the things, Mark and I, work on routinely is sort of helping companies come up with a search warrant response plan, and even going so far as to we can train employees on how it works, and you can even do mock search warrants.
You need to do a mock.
Believe it or not, it's not hard to believe. Federal agents showing up with bulletproof vest and guns and a search warrant, you might be inclined, or your employee might be inclined to be like, have at it, go on in. And so, they need to know what they can appropriately say, and sort of arm them with that information so that they're not, understandably intimidated into allowing more than a search warrant may require, and also putting forward a cooperative posture, because again, it's a delicate dance. You obviously want to protect your company against unwarranted intrusions, but at the same time you want to be a good corporate citizen and be cooperative and not obstruct any investigation. So that's, again, just sort of one of the types of things that I could see happening, more warehouse type raids, and so might be something you want to get ahead of and at least sort of have a plan of who does what when the time, when and if the time comes, and hopefully it doesn't. And I think another piece of this, and then we may wind up and take some questions, but is, and particularly going back to when you're doing business in one of these sensitive areas, whether it's Mexico or terrorist influenced areas, it's more enhanced financial audits on a more regular basis, because as Mark pointed out earlier, FinCEN and Treasury are going to have tons of data at their disposal already, and they are now focused on whistleblower programs, as well as just the overall national security focus of sort of all of the enforcement initiatives. So money is something that prosecutors love to follow. I, for one, used to get practically giddy when new bank records would come in. So making sure that you're having meaningful financial audits, and not ones that are just sort of rubber stamping the books and so forth, but ones that can catch, and are monitoring where payments are going. Whether are they going to shell companies? Well, what is that shell company? I mean, there are some legitimate shell companies out there, but you need to know your customer in the same way that banks are required to, even if that's not specifically written out in a law. You should be really doing much more on that front. Sorry, Mark, go ahead.
No, I'm agreeing, and yeah, know your customer, know your employees, particularly those overseas, and any contractors or vendors that you're doing business with. You have to make sure that your contracts with them, your agreements with them, are in line and protecting you as much as possible against any of these new enforcement priorities. Because again, it's not going to be good enough to say like, well, that wasn't really a concern before, it wasn't something that we looked at. You really want to make sure that their house is just as clean as your house, and that takes time, and that takes like several sets of eyes to make sure that you're as protected as you can be.
Right, and you know, obviously not every company is in a position to do this sort of searching due diligence, you know, in-house, and this is where again, outside counsel, and then some very good working with very good investigative firms can assist in really drilling down more so than just sort of the open source Google search that it seems sometimes is what is the only due diligence that's done. It needs to be more than that, and there are not just outside firms, but specialists that can help with this, and again, tailored particularly to those that are in sensitive areas.
And we've even developed some of those tools here at Thompson Hine. So
I would thank you all for joining us, and if there is a question that occurs to you, please reach out, with contact Mark or me or both of us. We'd be happy to chat with you about whatever your concern might be. But thank you all for joining us.